among the couples gets to be entitled to custody of the children to the marriage at the end of the marriage? When all walls come crashing down and the couples be like, sorry, we can't proceed with this union, let's go our separate ways. Who will the law give custody of the children to? And remember, the issue of custody usually come up when these kids are still minor and not adults, and therefore incapable of making their own decision. Stay tuned to find out who will be entitled to custody of the children as a matter of law. I want you to take home these points today. There is no hard and fast rule as to who is entitled to have the custody of children to the marriage at the end of every marriage. There is only one factor that the law puts in place in arriving at that decision. What is that factor? In arriving at a decision of who to grant custody of a child to, the court considers basically one factor, and that is what is in the best interest of that child. Now let us see what section 71 of the Matrimonial Causes Act says regarding the grant of custody of children. It says, in proceedings with respect to custody, guardianship, welfare, advancement or education of children of a marriage, the court shall regard the interests of those children as the paramount consideration, and subject thereto, the court may make such order in respect of those matters as it seems proper. I really want you to know that there could be circumstances where court will not grant custody of the children of the marriage to either of the both parents, when it's obvious that none of the parents will serve the best interests of the children of the marriage. And in such instances, custody could be granted to a guardian. Let's see what section 71 sub 3 of the Matrimonial Causes Act says with respect to granting custody of children to either of the parties to the marriage. Listen carefully. It says, in proceedings with respect to the custody of children of a marriage, the court may, if it is satisfied that it is desirable to do so, make an order placing the children or such of them as it seems fit in the custody of a person other than party to the marriage. Moving further down to 4, it says, where the court makes an order placing a child of a marriage in the custody of a party to the marriage or of a person other than the party to the marriage, it may include the other such provision as it thinks proper for access to the child by other party to the marriage or by parties to the marriage, as the case may be. So basically, the summary of section 71 sub 1, 3, and 4 is to the effect that what court considers in reaching a decision as to who to grant custody of a child to is what is going to serve the best interests of that child. And where such is done, visiting rights can be afforded to either of the party. So I hope you've learned something new today and disabuse your mind from the general perception that a child, as a matter of fact, must be granted custody by the mother. Will it serve the best interests of the child? That's all the courts care about. Thank you for watching and stay tuned to my channel for more of this legal advice. Thank you.